Joining us live to discuss is Erin Carr, Assistant Professor of Law at Seattle University. Erin, I want to start with what happened today. The High Court heard arguments on two cases challenging state laws banning transgender youth from participating in sports. We heard some skepticism from the conservative majority on the interpretation of Title IX and equal protection from lawyers representing the two transgender females. So what does that signal, do you think, about the future of gender identity protections under existing civil rights law?
Well, in the 5 years since the Supreme Court acquired a conservative supermajority, it has invited legal challenges aimed at curtailing civil rights protections and has, when given the opportunity, limited the applicability of civil rights law and constitutional protections for the LGBTQ community. In the two cases argued before the court today, even though lower federal courts have found that the challenged state laws violate the Equal Protection Clause of the 14th Amendment and illegally discriminate on the basis of sex, the Supreme Court appears prepared to allow states to ban transgender student athletes, which would be consistent with the Supreme Court's ruling last term in a case called Scrimetti, in which they upheld a state law banning medical treatment for transgender adolescents.
Also, over the past 2 weeks, as you know, the Trump administration launched a military operation in Venezuela, arresting the country's president. Also, a massive immigration enforcement operation in Minneapolis that resulted in the death of an unarmed American citizen, a mother. How should we view Trump's use of executive power?
Well, we are approaching the one-year anniversary of the second Trump administration, and over the past year, President Trump's use of executive power in both domestic and foreign affairs has frequently been described as unprecedented. And while that is a historically accurate description, what I fear is that the unprecedented expansion of presidential power that we're witnessing is quickly establishing a new legal and political precedent that normalizes behavior that has long been rejected as undemocratic and unconstitutional. As President Trump has been largely permitted by Congress and the Supreme Court to operate well outside of the confines of the law, he's been further emboldened. And it's for that reason that I view the seemingly distinct yet similarly tragic recent events in Minneapolis and Venezuela to be equally explained by a Congress that has abandoned its constitutional duties and oversight responsibilities in tandem with a Supreme Court that has radically recalibrated the balance of power and diluted checks and balances that have historically constrained the abuse of presidential power.
Let's talk more about that. How, if at all, has the current Supreme Court enabled the expansion of presidential power?
Well, before Donald Trump even returned to office last January, the Roberts Court had already created a legal foundation primed for executive abuse. On the eve of the 2024 presidential elections, the Supreme Court issued a sweeping opinion in a case called Trump v. United States, in which it held that the president has immunity from prosecution for any official conduct while in office. Functionally, the effect of that decision is that Donald Trump, while president, is the one person in the United States who is not subject to the law. And he knows that, and he has wielded the enormous power, resources, and authority of the national government with that knowledge.
And on ICE enforcement, as you know, the Vice President, Vance, last week said that the agent who killed Renee Good in Minneapolis is protected by absolute immunity. Is that the case?
Well, although there are challenges to successfully prosecuting law enforcement agents, states can do it. Federal officers who violate state laws can be prosecuted. Government immunity, importantly, only applies to agents who act reasonably in carrying out lawful government functions. And even in light of the considerable discretion that is afforded to federal law enforcement, killing unarmed civilians in a nonviolent encounter exceeds the bounds of lawful conduct. Federal agents who commit murder can be prosecuted under state law, and if convicted, cannot circumvent the legal consequences of their actions with a presidential pardon.
What are some of the legal tools that states can use if they are concerned about the use of executive power? For example, can states investigate, potentially prosecute federal agents, as you just mentioned, for excessive force? Are there some other tools that they can also use?
Well, although the federal government does have considerable power and resources, state officials are not without agency or legal recourse. Because there is seemingly little likelihood of accountability at the federal level under the current administration, states are now exercising their jurisdiction to investigate and potentially prosecute excessive use of force by federal agents to ensure they are accountable and are acting within the scope of their official duties. What we have seen in the last several days is that state leaders in Oregon and Minnesota are using the legal tools at their disposal to attempt to protect their residents from what are intensifying and increasingly common, well-documented incidences of ICE agents firing chemicals and arresting peaceful protesters outside of schools, detaining U.S. citizens, and violently attacking and in some cases killing people in American streets.
Well, this session for the High Court's just getting underway, so there will be much to discuss in the weeks ahead. Erin Carr from Seattle University, thank you so much for being with us tonight.
Thank you, Joyce.